Hello and welcome to A&M Bacon's podcast. I am today joined by Deputy Master Peter Howarth, who is our brand ambassador at A&M Bacon. Peter joins us today to share his overview of the recent Supreme Court decision made in the case of Ho and Adelakun. Peter, welcome.
Yes, good morning, and thank you for the introduction. So this morning I'm going to talk to you a little bit about set-off and enforcement in Quox proceedings. That's quite different beasts, I'd like to say, in the cost jungle. You've won your case, that's the good news, but what happens if you've slipped up on the way to winning the case and your opponent succeeded in obtaining a cost order against you? That might, for example, be an application that you've made. Let's say, for example, you want an additional expert's report, court's gone against you and ordered effectively costs against you, interlocutory costs, that is. So it'd be reasonable, would it not, to suppose when you get to the end of the matter and you've been successful, that your losing opponent effectively can reduce the costs that he owes you by the cost that you owe him. In other words, there is in legalese what's known as a set-off. The reality, of course, is that often this is often the case with costs, and civil procedure rules generally allow for it, and it's CPR 4412 which gives the court jurisdiction to order just that: set off the amount assessed against the amount the party is entitled to be paid, and direct the party to pay any balance. That's not the last word, though, and the recent case of Ho and Adelakun in the Supreme Court says that. Let's just look at the facts of that case to start with. The facts are absolutely simple, and they are set out really quite simply that Mrs. Adelakun was injured following a road traffic accident with Mrs. Ho in June 2012. The case proceeds in the usual way in the fixed costs regime under Part 45 of the rules, and some years later, Ms. Ho offers to pay Ms. Adelakun £30,000 to settle her claim. She also offers to pay her legal costs up to that point, the pre-settlement costs. That's accepted, and the whole thing's wrapped up in a settlement agreement, in other words, a Tomlin order. And that's important, and I'll come to that later. The way in which the costs order is expressed is also important, because as well as the offer to pay £30,000 in full and final settlement, the Tomlin order goes on to say, with costs to be paid in accordance with Part 36, Rule 13 of the Civil Procedure, such costs to be the subject of detailed assessment, if not agreed. And thereby was the problem, because on the one hand, effectively, Ms. Ho was saying, look, I can have costs the subject of detailed assessment pursuant to Part 47, and Ms. Adelakun's lawyers saying, no, you can't, you can simply have fixed costs, and those fixed costs effectively are set out in Part 45 and would total some £16,705.15 to be precise. Can't agree. It ends up going off to the Court of Appeal, and there are two actual appeals in this matter to the Court of Appeal. So it is quite a complicated case. And the case is notable for a number of reasons. Firstly, it's the first appeal that was dealt with via Skype for Business during the pandemic. Secondly, the court was invited to take a very rare step of deciding that one of its early decisions in a case called Howe and Motor Insurers Bureau had been decided per incuriam. I thought we'd got rid of Latin, but obviously we haven't. In other words, that it was decided through a lack of care. And thirdly, having concluded that that was not the case, the court nevertheless agreed that there was a powerful argument for calling the decision in Howe into question. So, as we'll see, there are two very powerful Court of Appeal decisions that effectively are conflicting. And as a result, in the second appeal in Howe and Adelakun to the Court of Appeal, the court gave permission for the judgment to go directly to the Supreme Court. Okay, so I've dealt with the facts. We know it's settled for £30,000 under a Tomlin order, which is an obligation to pay the damages which is set out in a schedule with a provision for reasonable costs on the standard basis to be the subject of detailed assessment if not agreed. So the decision for the first Court of Appeal decision was effectively, is she entitled to fixed costs, or is she entitled to costs to be assessed under Part 47? And the simple fact of the matter is that Part 45 costs had not been abrogated. The fact that the Tomlin order said costs in accordance with Part 36, Rule 13, such costs to be the subject of detailed assessment, didn't effectively mean what it said, that the offer had not been one to which the court could order fixed costs outside the fixed cost regime. So where defendants wish to make Part 36 offers on the basis that the fixed regime apply, they would be well advised to make an offer in accordance with Part 36.20 and not Part 36.13, and omit any reference to costs being assessed or to an assessment on the standard basis in any offer letter. Okay, so there you have it. So far as the first appeal is concerned, the situation is that Ms. Howe gets fixed costs and no more. So that leaves the vexed question of whether could Mrs. Howe set off that sum against the costs which Miss Adelakun was liable to pay her in respect of her success in the Court of Appeal. She racked up some £48,000 in costs in relation to going off to the Court of Appeal. Could she look to the damages that had been awarded of £30,000 for the purpose of and deduct them from what Miss Adelakun owed her under the Tomlin order? The question, that simple question, was decided in the negative, because effectively the obligation to pay had been recorded in a schedule and was not an order of the court. So it was a contractual agreement to pay. Consequently, there's no recourse to the damages for Mrs. Howe's costs. And that comes from an earlier decision called Cartwright and Vendat Engineering Limited. So set off appears to be her only hope. But having said that, in relation to Miss Adelakun's claim, that was for personal injuries, so she had Quox protection. Did that make a difference? And the answer is yes, it does, argued the Court of Appeal. The whole purpose of Quox was to protect the claimant from having to pay any costs of a defendant in personal injury claims. Quox regime had been implemented as a result of Sir Rupert Jackson's review, and only in defined circumstances could that protection be lost, specifically under 4415 if the act had been struck out, or 4416 if the court held that the claim was fundamentally dishonest. And here, certainly there was no striking out, there was no suggestion of dishonesty, so the Quox rules in that sense didn't apply, and all that effectively the Ms. Adelakun was left with, or I'm sorry, Ms. Howe was left with, was effectively a set-off under 44.12. There'd been a previous case of the Court of Appeal in Ho, which it effectively said that there was an ability to set off under the general law, and the Court of Appeal in Adelakun also found that they were bound by that decision and came to the same conclusion. But as I've indicated, did give permission to the Supreme Court to find otherwise, and that's precisely what they did. The Supreme Court was somewhat unhappy at dealing with this appeal, and they were quite concerned about the appropriateness of a procedural question such as this being referred to the court. The fact, they went on to say, the very fact that two eminently constituted courts of appeal have differed profoundly over the interpretation of a provision of the CPR suggests that there must be ambiguity which practitioners need to have sorted out. And they suggested that in future these sort of issues should be dealt with by the Civil Procedure Rule Committee. So what did they decide at the end of the day? Well, the court unanimously allowed the appeal. The court consisted of Lord Briggs and Lady Rose, who gave the judgment, and they explained that the effect of the rule 44.14.1 is to create a monetary cap on the amount the defendant can recover in costs from the claimant, set at the level of the aggregate amount of money in terms of all court orders for damages and interest in the claimant's favour. Remember, here there were no orders for either damages or interest, though it was a Tomlin order. It was an agreement, a contractual agreement. Consequently, the defendant must keep a running account of all cost recoveries it makes against the claimant and cease enforcement once that monetary cap is reached. Ms. Ho nonetheless argued that she could set off the opposing costs orders against each other because the monetary cap created by the rule only applied to the net costs liability of a claimant after all opposing orders had been netted off, and therefore, despite the aggregate amount of the court orders for damages and interest being zero, she still argued she could attach or set off against the £16,700 owed by her for the pre-settlement costs against the costs, Court of Appeal costs that were in her favour. The court rejected the argument and effectively said that a calculation of the claimant's net cost liability was therefore an incorrect approach, as the bar to enforcement in Kwok's provisions applied to the gross amount of the defendant's costs orders against the claimant rather than the net amount. The net effect of this is that Ms. Ho must pay Ms. Adelakun the full pre-settlement costs of £16,700 on top of the £30,000 agreed to in the settlement agreement, and can't enforce any of the Court of Appeal costs against the other party at all. The court recognised, I think, that this looks at first blush counterintuitive and unfair, but the conclusion they reached follows from the wording of the Kwok's provisions in CPR Part 44, and any apparent unfairness in an individual case is part and parcel of the overall balance struck by the Kwok's regime. So where does that leave parties? Well, I think it leaves parties to litigate in personal injury litigation. So for the claimant, it's important, I think, that where there are competing costs orders or cross orders for costs, that where the litigation is resolved and Kwok's is going to apply, and where there's a cross order, that you effectively make sure that any settlement agreement is in the form of a Tomlin order. And if you're acting for the defendant, then the opposite applies, and that really you need to see where there are cross orders and you want to have a recovery pursuant to the Quox regime by virtue of a formal consent order from the court. And of course, from the defendant's point of view, you also need to make sure you have an up-to-date calculation of the gross sum of cost orders that you wish to apply or that you wish to set off against any order for damages and interest. And remember, it's only damages and interest awarded to the claimant that you can take a pot shot at in the recovery of costs. A complex area of law, and it's an area I suspect that the Civil Procedure Rules Committee will look at before too long. So as a final pointer, keep your eye on the legal press as to what the CPRC are doing to see if this case prompts a rule change, which I suspect it may do.
Thank you, Peter. That was a really helpful overview to what is a difficult area. Once again, we really do appreciate you coming along and sharing your understanding of this case, and we very much look forward to hearing from you in our next month's podcast. Thank you.